Go ahead, sir. 6 minutes.
Thank you very much, Mr. Chair, and thank you, Mr. Light, for coming here and for the information and the work that has led to this investigation. And I would just note, and I guess this is a request because it's tough sometimes to get to the meat of the matter within the time frame of questions, but you did mention that there's some recommendations on how government can ensure that rights are respected while investigations take place. So if I could ask if you could either send to the committee specific recommendations. Generally, a recommendation can be, a couple of sentences. And your expertise, if you could distill that to a point where then the committee could say, okay, here's something that we could recommend to the government. And I would also just note, for your information, Mr. Light, I filed what's called an order paper question asking for some more details on this over the extent of the entire government. I know 13 departments were highlighted. Shared Services Canada had indicated that there may be more than 13, so I have asked this question, and I'm hopeful that the government will be forthcoming in that information. I think they have 45 days to reply to that, so that's probably in about a month and a half. I do want to ask you, if I could, you talked about the right to privacy, and that's been a human right in Canada, or acknowledged as a human right in Canada since the 70s. One of the things that I've found very interesting and has led to a host of concerns is that differentiation that you have of these very powerful forensic tools for use for administrative purposes within the context of a department. So to look at an employee's device and an administrative investigation, something to that effect, versus a court-ordered or a investigative purposes for somebody who is not an employee of the department, didn't sign in a terms and conditions contract, but rather is subject of an investigation or periphery, a witness to an investigation. So could I ask you to expand a little bit on what the difference is and how one reconciles the difference between the use of these very, very powerful tools for administrative purposes within, say, a department or agency versus for investigations where they would be used on Canadians, whether with judicial authorization or the various other forms to which we've been told that they could be used?
Sure. So I think regarding use internally, I think that most of the agencies that have testified so far say we use them on our employees and we get their consent. I think that it's difficult, if not impossible, for employees to actually give informed consent in these situations, that there's an imbalance of power and there's an imbalance of knowledge. We've seen in the sessions of this committee just how difficult it is to explain what these devices are capable of. And consider if you were a junior employee and your manager says, we're going to use this device on your cell phone, you have no real alternative other than to say yes. And so I think that there's I think the use internally is quite fraught and imbalanced. In terms of its use with warrants, I think that there needs to be a step before you get to a warrant. That we should talk about necessary and proportionate. There are questions that we should ask: is this technology valid to be used to begin with? And this is where privacy impact systems come in, which personally I think are useless to a degree. They basically account to self-regulation right now, and so there's no process to which agencies or ministries are obliged to go through that would forbid them from using any technology. We saw this in Scott Jones's testimony on Tuesday, that he will buy this for anybody in government who wants it. There's no standard, which is mind-blowing.
It's interesting you bring that up, and I've been very I think forthright in my advice, and I think I reference it as unsolicited advice. Pick up the phone and call the Privacy Commissioner. We have an independent officer of Parliament. Any and all departments, agencies are a function of Parliament. I think often that gets forgotten. So specifically with privacy impact assessments, I think would you agree that if departments, agencies, and the government in general, if they were more forthcoming, doing things like privacy impact assessments, doing the outreach to the Privacy Commissioner prior to the use of these tools, do you think that would go a long way in helping ensure that the trust that I think Canadians expect that they should be able to have with government could be restored?
I don't think it will be enough. I think that the Office of the Privacy Commissioner should be properly resourced and empowered with judicial authority and with proper financial resources to be a proactive regulator. That in the whole process of procurement, they should be the ones who decide whether technology should be used or not, and in what use cases. I think that agencies themselves are in a conflict of interest, really, when it comes to making their own decisions around whether things should be used or not, that there should be an objective arbiter, which should be the OPC.
Okay, so you're suggesting going beyond the privacy impact assessment and ensuring that there is more steps and more tools that
Absolutely.
the
I
office has.
think privacy impact assessment is a useful tool for getting people, individuals, and agencies to think about these ideas.
Yeah.
I don't think it's a useful regulatory tool.
So if I could, just in the few seconds I have left, if you have those specific recommendations, please feel free to send them to the committee. Often, if it's a sentence or two that articulates exactly what you've suggested, and with your expertise and background as well, you're welcome to send supporting documents as well. And I know that there's a ton of other information, but please feel empowered that you're welcome to send that to the committee after your testimony here today.
Thank you,